Okay, we are now on the record, and this is the case of Sanitation Strategies LLC versus Troy Livingston and Rochester Midland Corporation. It's docket number 19-803CB, and this is the time set for hearing on the plaintiff's motion for leave to amend the complaint. And before we begin with your argument, may I have counsel's appearance for the record, please?
Dean Pacific, Your Honor, on behalf of the plaintiff Sanitation Strategies.
Good afternoon, Your Honor. Scott Eldridge on behalf of both defendants.
All right, thank you. And Mr. Pacific, this is your motion. You may go ahead.
Thank you, Your Honor. This is, as you noted, a motion to amend the pleadings, in particular amend the complaint in this case. It is an early, timely motion. The parties agreed on a date that you then entered into a scheduling order for motions to amend the pleadings. And this was filed well in advance of that date. I know the court is familiar with the standards for leave to amend, and we've cited those in our brief. Leave to amend is freely granted, of course, with very limited exceptions. The defendants, I think, concede that other than the futility grounds, they have no grounds to oppose. There's no question about timeliness, bad faith, dilatory motives, undue prejudice, or anything like that. And I say they rely on futility to oppose it. It appears they oppose it, at least in part, on that basis. They appear to concede that amendment is appropriate to add the tortious interference claim in the first amended complaint. They don't advance any argument about that in their response. And with respect to the breach of contract claim that you've already held that we have a likelihood of success on the merits of, all they really say there is that it's improper to amend, to expand a breach of contract claim to include new information that we've obtained since the initial filing. They don't really explain why or how that's improper, and I think that's because it's not. That's what amended pleadings are for. But really the gist of their argument, or the main focus of their argument, is the conversion claims. And it's important to note here, the futility analysis employs the MCR 2.116C8 standard. The claim has to be legally insufficient on its face to be found futile. There is not, despite some of the comments that they make in their brief, any requirement that conversion be pled with specificity. Even the Hance case, the 140-year-old case that they cite in purported support of that proposition, was not decided at the pleading stage and doesn't so hold what they claim it does. That was a case that was actually decided after a full trial. And I think that kind of goes to, I think, the gist of how I would reply to their response in opposition is that they've briefed this whole thing as if we were in a post-trial brief here, or at least a C10 motion, when in fact we're just at the pleading stage here. And I think that's indicated where you see that virtually all of the cases they cite are appeals from trials. The Hance case, the Stone Computer case, Harper, Lettinga, Sarver, all of these cases are post-trial appeals. A couple of them are federal summary judgment motion appeals, the Miracle Boot case and the Boyd case, which is a federal bankruptcy case. But even in the Miracle Boot case, the federal appeals court there reversed the grant of summary judgment and sent the case back for a trial. So that's where these cases are getting decided, not at the pleading stage. And I think the record shows that we've pled more than enough to state a claim for conversion in the first amended complaint. Again, most of their complaints relate to a purported lack of specificity. Aside from the fact that specificity is not required at this stage, we do in fact plead quite a fair amount of detail and more than is required on the conversion claim. We've alleged that Troy Livingston took and retained a USB drive containing over 300 Sanitation Strategies business records and documents. And that's just the ones we know about on the one device that he returned after the court ordered him to do so. And we talk about that at paragraphs 50 to 52 of the amended complaint. We provide more detail than is required because we do provide a number of categories of information that were on there, including customer pricing and profitability information, names and addresses of customers, technical data related to proprietary chemical products, sales presentations, customer proposals, as well as system specifications for a proprietary data management system. And the other thing that's important to note here is that defendant's counsel has a copy of this thumb drive. So we weren't required to be more specific in the pleadings, but even if we were, there's no mystery what's on there. Defendant's counsel has a copy of it and has every single one of these documents in their file. And so they can't pretend not to be aware of what the contents of that drive are. And we've also identified very specifically 2 other USB drives that were plugged into Mr. Livingston's computer on the last day he worked there. We've alleged that he was in sole possession of that computer. And as the court noted at the prior hearing, of course, we don't yet know everything that was on those other 2 drives because he's had exclusive possession of them, but we have identified them very specifically, the dates that they were used, and we've alleged on information and belief that he downloaded additional records onto these drives, which I think is a reasonable inference under the circumstances. To the extent that the defendants argue that we haven't alleged that we own the USB devices themselves, that's simply not correct. I think it's probably irrelevant, but in any event, it's incorrect. We've alleged in paragraph 30 of the complaint that under the party's contract, and this is a quote here, both from the complaint and also from the contract, all documents and tangible things, including diskettes and other storage mediums in any tangible form containing information generated in the course of employment are the property of the employer. So we have in fact made that allegation. In terms of defendant's argument that somehow this information isn't sufficiently tangible property to be subject to a conversion claim, that's contradicted by the very case they cite, the Sarver case. The Sarver case said that an idea wasn't a sufficiently tangible piece of property to be converted, but they say in that case, and I'm quoting from page 586 of the Mishap opinion, 225 Mishap at 586, the doctrine of a conversion has not extended beyond the kind of intangible rights which are customarily merged in or identified with some document or other tangible property. So an idea wasn't sufficient, but here we have exactly what the court talked about in Sarver. We have something that's merged in or identified with a document or other tangible property. In this case, both the business records that are on the USB device as well as the USB device itself are the property of my client. And I'd also note that to the extent they've argued that we haven't alleged sufficient dominion and control over the converted property, the Aroma Wines case that they cite held that moving wine that belonged to the plaintiff from one location in the defendant's warehouse to another location in the same warehouse was sufficient dominion and control to support a conversion claim. If that's sufficient, I'd submit surely taking at a minimum 300 plus business records that you've agreed are the property of your former employer, making false statements indicating that you have in fact returned them all when you haven't, and then keeping and using them for 2.5 years is certainly sufficient exercise of dominion and control. And again, particularly here at this early pleading stage of the case. So we would submit, Your Honor, that this amended complaint easily meets the notice pleading standards that apply here. There is no requirement to plead conversion with particularity, although we've pled it, I think, with more detail than it's typically pled and more than is required. And so we would respectfully ask for leave to file this first amended complaint.
I have one question.
Yes.
And this is very narrow, but even at the pleading stage, you have to allege the elements of the claim. So would you respond to the argument that on your statutory conversion, there's no allegations that RMC had actual knowledge of alleged stolen, embezzled, or converted property?
Yes, 2 things about that. I think, first of all, they only refer there to subsection B of the conversion statute, but both subsection A and subsection B of that statute would apply here. And there is no knowledge requirement for subsection A. The conversion statute there doesn't require knowledge. They're liable under that section as well. And we've alleged Troy Livingston was acting as their agent when he made these acts of conversion, in particular in paragraph 46. I note that allegation in other places as well. And again, even under B then, where knowledge is required, Troy Livingston, we've alleged, was acting as their agent, and he certainly knew it was converted, and that's established in the allegations, for example, about his false statements about having returned the information. And again, the last thing I would say about that is even where specificity in pleadings is required, for example, in a fraud claim, which is covered by a different subsection of MCR 2.111, knowledge can be averred generally. And I think with those allegations I've referenced, we've certainly alleged it sufficiently to meet the pleading standard.
All right, thank you. Mr. Eldridge?
Yeah, thank you, Your Honor. It's clear to us, and I want to address Mr. Pacific's specific points, not each one, because I think our brief sufficiently addresses most of the arguments that he's made, and I don't want to regurgitate our arguments, but I do want to touch on a couple of items that he mentioned. But before I do, I just think it's certainly clear to the defendants that the plaintiff's theory here has significantly pivoted, and it's pivoted away from what we originally saw as a breach of contract claim, a trade secrets claim, and a tortious interference claim, all based on this 28-point inspection. Well, after Your Honor had concluded that it was unlikely that they would prevail on the merits of their claim that the 28-point inspection amounted to a trade secret, they've effectively abandoned all of that and now have shifted to what is really a series of claims based on things that they can't articulate. It is unclear to us what it is, what property of sanitation strategies that the defendants supposedly misused or converted. And despite counsel's suggestions to the contrary, Michigan law does require specificity at the pleading stage. And that's because a complaint, although we are a notice pleading jurisdiction, a complaint still has to assert plausible facts that can maintain and sustain a plausible cause of action. And the case law, while a lot of it is post-discovery that we cited, it does inform the court about what the basic legal standards are in terms of how can you establish at the very baseline what, as a matter of law, amounts to conversion. First, what can be converted and what is actual conversion. One of the cases, though, that we cited prominently in our brief that Mr. Pacific left out of his presentation to Your Honor is the Micron versus Omega case. The Micron versus Omega case is out of the Eastern District of Michigan. It's a federal decision, of course, but it's from 2017, and it addresses Michigan law. And the Micron decision was at the 12B6 stage. And the court in that case specifically held that the plaintiff's statutory and common law conversion claims were dismissed at the 12B6 stage for offering only bare recitation of the elements and failing to identify any specific property at issue. At issue there were the types of materials that the plaintiffs here assert as having been converted. Things in the Micron decision, such as customer lists and confidential business processes and methods that were allegedly converted and retained, and that the defendants allegedly retained certain account information. Well, the court went on to reject those claims and dismiss those conversion claims at the pleading stage because the complaint did not identify which specific revenues or assets or accounts over which the defendants allegedly retained ownership at the deprivation of the plaintiff. And that's really what we have going on here is we have a lack of specificity to where I don't even think I can articulate to you what it is exactly that they think our clients converted. I understand that they cite in broad terms to the content of the one flash drive, but they don't identify what in that flash drive it was that we actually converted. We can't defend a claim without that kind of specificity. I have no idea what it is they think we converted. Now, I do have a copy of that flash drive because we turned it over to Mr. Pacific and his team in response to your TRO order. And what's on there, Your Honor, are the very kinds of things that are at issue in the Micron case, none of which is marked as confidential. Some of it is mere draft letters to clients of sanitation strategies that just say, hey, please hire sanitation strategies because we're really good at what we do. Now, if that's what we're talking about as having been converted, then they should be able to identify that. And so we know exactly what we're talking about. And now we're not embarking on a fishing expedition or wild goose chase with respect to discovery. And that's precisely why we opposed the motion to amend the complaint, because, and Mr. Pacific is right, we're not opposing every single aspect of it. I think at the end of the day, what we're really asking for, Your Honor, is for purposes of going forward, we understand that your previous ruling allowed the original breach of contract claim to move forward as is. And we're not certainly asking you to reconsider that. We're just suggesting that with respect to breach of contract, we shouldn't have to defend against claims where they can't identify what it was that we misused to form the basis of the breach of contract claim. The original claim was based on the 28-point inspection. I understand that. They've identified it. The rest of it is really the functional equivalent of them coming to court saying, Judge, we don't really know what it is that they misused, nor do we really know to which or which clients they shared it with. And we really don't know how much it's hurt us. Therefore, we really need the defendants to tell us all of that. And that's not how litigation works, of course. They have to identify the plausible facts that can support a claim at the end of the day. So we're asking that you not kind of expand that breach of contract claim to include the flash drives. And that's one, because the one flash drive I mentioned, it's unclear to us what it is that we allegedly used as part of a breach. And they don't say anything in their complaint to that. And that's a pleading problem. With respect to the two other flash drives, I don't know how they can proceed as a matter of law when they don't know what the flash drives or where they are. They don't know whose they are, and they don't know what, if anything, was ever actually on those flash drives. That seems to be a pleadings problem too. In other words, they want to pursue a breach of contract claim over material that nobody knows even exists. And it's a fundamentally fatal to their breach of contract claim as it's been presented in the proposed amended complaint. With respect to the conversion claims and the accounting claims, we think those are dead on arrival for the reasons we stated in our briefs. And we're absolutely opposing the motion with respect to those claims because they are futile, and this court has an obligation to act as a gatekeeper to avoid allowing baseless claims to proceed and bog the parties down in unnecessary discovery. Again, we're talking about material that is not even the proper subject of a conversion claim for all the reasons we cited in our brief. And we're also going to, by denying the motion to amend the complaint to include the conversion claims, we're going to rein in discovery. Otherwise, the parties are going to be chasing down two non-existent flash drives that nobody knows where they are and expending resources unnecessarily for a claim that ultimately, at the end of the day, is not the proper subject of a conversion claim. The same goes for the accounting claim. The accounting claim is one that's really not appropriate in this case. Those sorts of claims are unusual, admittedly, and they don't come up very often, but where they do come up is in the context of the plaintiff and the defendant actually having business relations together, where there are mutual demands, as we explained in our brief, and that's mutual demands between the parties. The parties here are competitors. They don't have business relationships together, at least not based on the allegations of what transpired, which is all post Troy Livingston leaving Sanitation Strategies. So we don't even have the correct kind of situation that would make an accounting type claim relevant. Moreover, effectively what they're saying with their accounting claim is, Judge, we have no idea if we've been damaged or whether we've been damaged. We really just need the defendants to tell us where they've made money and and explain to the plaintiffs what the defendants' relationships are with their customers. Again, not an appropriate use of an accounting type claim. We did not challenge the proposal to amend vis-a-vis the tortious interference claim, and that's true. We didn't oppose it, and so while we believe it is insufficient and they won't be able to prove the case down the road, we're not challenging that aspect of their proposed amended complaint at this time. So what we're left with, Your Honor, is really the original complaint with respect to the breach of contract claim as pled in that case or in that complaint, and the new tortious interference claim. And with that, Your Honor, I'm happy to answer any questions because I know you've read our briefs. But if you don't have any questions, we simply rest on our briefs.
I don't have any. Thank you. Mr. Pacific?
Yeah, just very briefly, Ron, I'll say, again, I think most of Mr. Eldridge's arguments sound like C-10 arguments. And, to argue that, we can't prove exactly which of the 300 files he might have used to call in which particular customer. Well, of course we can't because we haven't taken any discovery yet. We're at the pleading stage. And so those things will happen. But, I continue to be confused by the argument from the defendants that somehow to pivot or expand a claim based upon things that you discover after you filed the initial claim, things like, oh, by the way, this employee, stole a thumb drive with 300 plus documents on it and took 2 others that we need to find out what is on is somehow improper. That's precisely what amended pleadings are for. And this is an early, timely attempt to do that. I don't share the view that it's going to create any discovery problems. Mr. Eldridge and I have both been doing this for a long time. I think I had 1 motion to compel all year last year in any of my cases. So we'll be able to work through discovery reasonably. But, again, this is an early, timely motion. Leave to amend is freely given. The futility arguments just don't play here. Even the one case that they cited, after I listed the litany of post-trial cases, he turned back to this one unpublished federal case, Micron. That's a completely different case. That's a conversion of money case where you just typically can't state a claim for conversion, period, for conversion of money. Again, unless there was some sort of, relationship between the parties where you were, handling specific funds like a consignment or something like that. So that's a totally different situation than what we have here. But all of the rest of these are post-trial decisions. That's where I think we need to go here. We need the opportunity, like all those parties had, to develop the case through discovery. And I don't foresee that being a problem. And with respect, finally, last thing I'll say is with respect to the, the equitable relief or equitable remedy set out in the last 2 counts for accounting or injunctive relief, those are just equitable remedies that the court may or may not ultimately, after the claims are fully litigated, decide are appropriate. But we both agree that sort of equitable relief would be decided by the court. And it's just premature at this point to decide whether or not it'll apply here. We've incorporated by reference in each instance, the prior allegations. So basically, what we're talking about is those are just 2 potential types of relief in addition to the other relief requested that might be available. Certainly injunctive relief could be appropriate. You've already entered a preliminary injunction in this case, and we certainly reserve the right to seek an appropriate permanent injunction, again, depending upon how the case develops. But at this pleading stage, for all the reasons that I've discussed here and that are in the record, I believe we established we're entitled to file the first amended complaint. Would respectfully request we be permitted to do so.
All right, thank you. This is an early and timely motion to file an amended complaint. The only objection that's made here falls under the category of futility. And at the outset, I just want to lay out that futility is judged like a C8 motion for summary disposition. And that is, you look at the claim and say, would it fail as a matter of law? It's not judged as a C10 motion. So the court doesn't assess whether it's provable at this point. So with that standard that applies to all of these different arguments that are made with regard to the proposed amended complaint, the defendant does cite to a number of cases that deal with the ultimate proof of a claim. So I do agree with the plaintiff that a lot of these cases, none of them are really binding. There are a lot of unpublished cases and some federal cases, so they're not binding precedent on this court, but they deal most often with the ultimate proof of a claim and not with whether the pleadings are sufficient as a matter of law. The claim, though, is made by the defendant that the proposed amended complaint fails to identify the property that's been allegedly converted with specificity. I do have to disagree with that proposition. There is, first of all, the one USB device that is known, and has been turned over to the defense. And paragraph 51 of the proposed amended complaint alleges that that USB has customer pricing and profitability information, names and addresses of Sanitation Strategies customers, technical data information for proprietary chemical products, complete sales presentation slideshows, specific customer proposals, as well as system specifications for sanitation strategies, proprietary sanitation data management system. I believe that is a sufficient degree of specificity. Now, there is, of course, the issue of the 2 USB drives that are not recovered, that have been unable to be found at this stage. But I don't think that fact makes the conversion claim fail for lack of specificity. The plaintiff does have evidence and allegations that there are 2 additional thumb drives that exist, and has evidence of the circumstances under which those thumb drives were allegedly used. And I don't think that just because we don't know what is on them particularly at this point, there are certainly allegations that could reasonably lead to the conclusion that they are business records of plaintiff, even if we don't know precisely what they are. I think that is a matter for the proofs in this case and for discovery. So I don't think that the proposed amended complaint fails for lack of specificity. Oh, there is another argument that the defendant makes, and that is that there's no tie to any lost customers, but that's an issue of damages and the proofs to be made ultimately in this case. So I don't think that the proposed amended complaint fails for lack of specificity. The defendant has also argued that the property at issue is intangible and it's not subject to a conversion claim because it's intangible. But again, the defendant cites 2 unpublished or non-binding cases. The conclusion that I would draw from looking at those cases for guidance is that intangible property may be the subject of a conversion claim when it's represented by or connected with something tangible. And that's what I get out of the Jason Armstrong DDS case. Where they said goodwill is not such a thing. But here, the allegations are that these were business records and business information. I would reject even the argument that that's intangible. Just because it's converted to an electronic document does not mean that it's intangible. These are tangible items, business records. But even if we say, okay, it's in an intangible form, it's still connected to something tangible, and that is the actual business records. So I reject the argument as well that this is intangible property and not subject to a conversion claim. And then related to that argument is the defendant's argument that there's no act of dominion or control sufficient for conversion. And the defendant cites 2 cases saying that the act of soliciting customers is not an act of dominion and control. I believe that's in the Micron, M-I-C-R-O-N case, and in the primary insurance agency group case. But in each of those cases, well, in Micron, there's a multitude of different issues. But in each of those cases, the court said that there's no dominion or control because the defendant merely had knowledge of the plaintiff's customers and used that knowledge to solicit them. There may have been documents in Micron, but they were unspecified documents. But they were talking about basically knowledge, such as in the primary insurance agency group where the defendant had knowledge of the customers and ultimately went to the phone book and looked for people of a certain ethnicity And the court said that you can't have dominion or control over something like that. Knowing about something that belongs to someone else, even if you use that knowledge improperly, isn't an act of dominion or control over the property. Here, the plaintiff isn't just alleging that the defendant just knew of customer information. The plaintiff is alleging that the defendant actually took business records, and business records can be the subject of someone's dominion and control. So I have to reject that argument as well. Then there are the arguments about the statutory conversion claim proposed in count 3. And first, with respect to Mr. Livingston individually, the defendant says there's no allegations that Mr. Livingston used the property for a purpose personal to his own interests. And while I agree those precise, specific words are not alleged in the complaint, I've read the complaint the proposed complaint as a whole. And I think as a whole, we can conclude that those allegations are existent. The complaint as a whole is alleging that Mr. Livingston retained business records that belonged to the plaintiff and that contained the types of business records that I've already listed, that I won't list again, that are set forth in paragraph 51 of the proposed amended complaint. And that he did it, if again, reading the complaint as a whole, for economic benefit to further his own employment as he's now employed by defendant RMC. So I don't think that the complaint fails in that regard either. With respect to RMC, who also is under the statutory conversion proposed claim, the defendant says that there's nothing alleged that RMC had actual knowledge of allegedly stolen, embezzled, or converted property. And the plaintiff, I think, successfully points out that Livingston is alleged to be an agent of RMC, and the liability under subsection A of the statutory conversion statute does not have that knowledge element, and that if he's acting as an agent of RMC, that establishes the liability of RMC for his knowing conversion of the plaintiff's property. Next, the defendant argues that there is no valid claim for an accounting. I do agree with the defendant on this one. Accounting is a claim where there are transactions between the plaintiff and the defendant. Here, the proposed first amended complaint alleges transactions between the two defendants, Mr. Livingston individually and RMC. And really what the plaintiff is seeking here is not legitimately an accounting, but discovery. And that is a matter that can be discovered in the course of the discovery period in this case. I don't think it's an appropriate claim for an accounting, and I think that fails just as a matter of law as what an accounting claim is, and the fact that this is just information that can be obtained through discovery. The next argument is that about the injunctive relief, there's no independent claim for an injunction. Well, if it is shown that Mr. Livingston converted business records belonging to the plaintiff, or that RMC is liable for such a conversion, then equitable relief may be appropriate. And as has been pointed out, the court's already granted some equitable relief in the form of an injunction in this case. So I think that argument fails as well. And then the last argument is that the breach of contract claim, as it's constituted now in the proposed first amended complaint, is unsustainable. Again, I disagree that there's no specificity as per paragraph 51 of the proposed first amended complaint. And then again, as to the two unrecovered flash drives, there are allegations that of the fact that they exist, the circumstances under which they were used, And I think it's a matter of proof and discovery as to what specific records may be on them. So I reject that. And again, the argument is made that there's no tie to any lost customers. And that, again, is a matter of proof ultimately in the case. And I don't think it causes the proposed First Amendment complaint or any part of it to fail as a matter of law. So for those reasons, I am granting the plaintiff's motion to file a First Amended complaint with the exception of the accounting claim that's in their count 5 proposed. And but I will grant the balance of the proposed First Amended complaint that it may be filed. And Mr. Pacific, if you want to do an order that reflects that.
I will, Your Honor. Thank you.
Okay, and in case you don't know, the circuit court is taking filings by email. If you maybe you do know that.
My secretary has been using that option now, so we're familiar with it.
Great, so you can proceed with that.
Yep, very good. Thank you.
Your Honor, may I ask one point of clarification?
Yes.
Thank you. With respect to the complaint that's going to go forward, is Mr. Pacific expected to amend it slightly so that it eliminates the accounting claim, or are we just going to ignore that and he's going to rely on what he submitted in connection with his motion?
I think you should amend it and just omit the accounting claim and renumber the counts.
That was
hasn't been filed yet anyway, so.
correct. Yeah, that was my assumption. That's what I'll do. I'll just remove that count in those numbered paragraphs and move the last one up and everything else. No other changes, obviously.
Yeah.
Thank you. Thank you.
Thank you. That'll conclude our hearing.
Thank you, Your Honor.
Thank you, Your Honor.
Have a good day.